Hi, Bill Henshaw here again for the Constitutional Crisis Channel. Today's video, and it's going to be a bit of a longer one than you've seen if you looked at any of the previous ones on the website, and I hope you have on YouTube. It's going to talk about issues in the traffic court. What do you do there in the various stages? And up front, I should say, this is equally good in quote-unquote criminal cases generally as well. It works across the board. Okay, the first thing with traffic tickets, though, that's different from an ordinary quote-unquote criminal case, is you normally, at the scene of the crime, quote-unquote, are asked to sign the ticket, and if you sign it, they'll release you and you can go on your way. Well, all well and good, but what they don't tell you is by signing the ticket, you're going to find out when you get to the Court of Appeals, if they take your case at all, and they're not required to do that, that when you signed the ticket, you waived the jurisdictional arguments. Well, that's odd, because it seems to me like you should be entitled to representation of counsel at that point in time in the proceedings if they're going to make a claim that you have voluntarily, knowingly, and intelligently waived rights. That argument's for a little bit further down in the video, but nevertheless, it's an interesting thought when you're in the car and the cop has stopped you and they want you to sign the ticket. But we do have a way to take care of that, so you can go on down the road and the cop won't be any the wiser. Just as they don't tell you all of what's going on behind the scenes, we are under no obligation to tell them, are we? So, okay, you get the ticket on the bottom. Before you sign your name, you write in CF, and that's all you write, CF, and then you sign it. That's Latin for coacta specie, which means under duress. That creates an issue for the jury, if you ever get in front of one, to challenge jurisdiction and say, yeah, I signed it, but there's a lot of fraud and deceit here, not to mention treason, that they didn't tell me before I signed the ticket, and that you as a jury, having the right to rule on the facts and the law, can take into account here, and this sets the factual foundation and legal basis for your jury instructions to be relevant. The black robe bastard denies him. He's running the risk of reversible error, number one. Number two, proceeding against you without jurisdiction at all. And if that's true, it now is going to make the bastard liable in a subsequent lawsuit. And I'm not talking about civil rights here. Common law suit and a common law court. Just how powerful this stuff is, and they know it. So you sign it CF, and by the way, a quick note here, there are people that advocate using UCC 1-207, and I don't have any problem with that. That's basically the statutory form of invoking your savings to suitors clause rights to common law remedies. But if you use that, it seems to me that's acknowledging the very authority that we're challenging. If they enacted the UCC, why wouldn't the statute that you violated be an equal exercise of jurisdiction that you can't challenge? For that reason, I don't do it. I want to keep it simple here and not give him any escape hatch. Okay, now you got the ticket done, and it goes through a process in jurisdictions, and it takes probably 2 or 3 working days, depending on where you are. But if I could do it at the first opportunity on the next business day or the day after that, I would go down with some of the documents that are going to be available. You'll see later on that you can ask me about what's available by email at ccaspari@live.com. That's CCASPARI at LIVE.com. And I got a whole packet full of documents, none of which they're going to be pleased to see, all of which they're going to be required to file, and this sets the record. And it's going to make you just as unbeatable in their courts as I am. Okay, that said, we go on, and first day you get an opportunity to do it with a witness if you can. You go down to the office of the clerk of the court, could be the traffic court, quote unquote, in California, and you attempt to get them to receive, not file, receive. There's a big difference here. A demand for a bill of particulars, which by this time we've already mailed a copy to the district attorney to be filed in that office, and with the return receipt, so they have to acknowledge that they got it. And what that does, see, you have a right to know the nature and cause of the accusation. But if you don't raise it in a timely manner, and I'm damn sure going to tell you right now that no licensed state bar attorney in his right mind is going to do something like this, even though they may know about the BOP, you've waived it. Now, nature and cause means basically the jurisdiction they're exercising. And you may think, especially out here in California, oh gosh, that has to be common law because California was admitted as a common law state. Yeah, it was. It's not one anymore, and for reasons that we don't have fully pinned down, although the document package I have on this is incredible and irrefutable. As you'll see, you request it and you'll see what's going on here. So no, we're not in a common law court. And we're entitled to one in the first instance. We're entitled to judicial courts and judicial process by the Constitution of the United States. And your state constitution too, in all probability. But they never let it on unless you raise the issues timely. So that's what you want to know. What jurisdiction am I in? If it's not common law, is it equity? Well, equity doesn't have any criminal jurisdiction, so you can rule that one out. Is it admiralty and maritime? And there's a heck of an argument there. That's exactly what it is. But you then find out if you're in a state court, and that's not where we are, they're flatly prohibited from exercising admiralty jurisdiction. How is it that they're doing it anyway? Oh, you're going to love it. You just check with my document packet. I've got the answers to this one too. Hey, is it martial law rule? That's the one I think it is. And for that to be in effect, there has to be a known declared state of rebellion or invasion under Article 1, Section 9, Clause 2 of the Constitution of the United States. Now, I don't know about you, but I've been looking around for 4 decades in the law library and other places to try to find out whether there's been one of those declared. And I ain't found one. The Supreme Court says, by golly, in a case called Ex parte Milligan, Milligan, for Wallace 2, which I believe is 75 United States, page 2, that you can't do this, and they set the petitioner free right during the war between the states, set the petitioner free and vacated his death sentence because an Indiana military court tried him and was about to put a rope around his neck, but the problem was there had been no declared state of rebellion or invasion. And by the way, in case you're getting misled here, states of emergency, quote-unquote, don't count here. It doesn't matter whether there's one of those or not. It has to be a state of rebellion or invasion. So that beats them. So no matter what jurisdiction it is, by the way, the only remaining one is the Uniform Code of Military Justice, and unless you happen to have orders that you've been inducted into the armed forces, you're probably safe there too. It's an interesting story for another video about that one. But trust me, whatever it is they think they're using, we can beat them across the board. Doesn't matter. And they're required to tell you, and in olden times, days in the 19th century, they did on the first page of the complaint, especially in federal courts, it would say what it was. For example, a libel, which is the old-time name for a suit in admiralty and maritime. And that puts the defendant on notice what the jurisdiction is, and especially in the case of admiralty, that tells the defendant he better damn well assert his savings to suitors' rights if he wants a common law remedy, namely a trial by jury. Fair is fair. They should still be doing that. A good case, by the way, on this subject you can read, is a relatively short one, is United States versus Smith, 776 Federal 2nd, pages 1104 et sequel, discuss the Bill of Particulars. You'll get a good read on that. You can Google that. It'll pop right up. And all these cases you can check in the notes below. You'll see the proper citations. I'm sure this is one of those. On occasion I may slip up, but not often. So we get to that. So you've gone and you've done that and filed the Bill of Particulars. The next thing I file, and this one you file with the clerk of court as well as the DA, and you can send one to Sacramento Shamla out here to the Attorney General, or the Attorney General in your state, is a notice of denial of counsel. This is not a moving paper. It's not a motion. You're stating the law, which we can do in our own courts, and you're saying, in effect, I'd love to have your assistance of counsel, but the problem is, as we both know, and there'll be lots of support in here to let them know what the problem is, and they're going to get hit with about 100 pages later, is that your counsel is a member of the State Bar Association, licensed member. As such, he's an officer of the quote-unquote court. His appearance gives them general jurisdiction and waives any jurisdictional arguments you might have. So even if an attorney like that knows about these issues, and even if he's willing to raise them, and I bet you not 1 in 10,000 would be, he can't go in and do it. You have to be what the court calls a belligerent claimant in person to do that. Okay, and you can't do it by an attorney. Simple as that. Number one, Number two, as an attorney, he has some irreconcilable differences with you because the issues that we're going to put in there are going to directly challenge their malevolent monopoly on the practice of law. If we win one case, one big win like this, it's gone. And we get 50 for one. If I beat him here in California, it's good for every state we have out there. Of course, there are none of those. That's another story. But, that's a biggie, is that they do that. Number two, it gets even worse because the issues we're arguing, if we get back to the Reconstruction Act and the 14th War Amendment, and we win there, our citizenship gets restored as it should be. The citizenship of the attorneys and the quote-unquote judges disappears because they've claimed under penalty of perjury that they owe their quote-unquote citizenship to Section 1 of the 14th War Amendment. Has to be, because they all filled out voter registration forms at least, and licenses and other things like that, you name it. They've said it multiple times, and they've been to law school, right? What do they tell us? Ignorance of the law is no excuse. Your citizenship is gone, and the hell with you. You can become a stateless entity like what you've been thinking that we are for the last 80 or 100 years. And see how you like it. So that's how important this document is, and counsel is the only issue they think they have to respond to at all. The only one, and even then, I read cases, and I'll get you a cite on this one later, not in this video, but I swear to God, I read a case in the appellate court where the attorney for the accused basically fell asleep throughout most of the trial, and the appellate court didn't have any problem with that. They sustained the conviction anyway. This is how crazy this is. So no, you would love to have assistance of counsel if they knew what they were doing and would obey their oath of office, but they're not going to do it. And without that, the Supreme Court has said, and I quote here, let every judge know at the start of a misdemeanor trial that the accused cannot be sent to jail though local law permits it if he was not represented by counsel at his trial. Case is Argersinger, Argersinger versus Hamlin, like the Pied Piper, 407 U.S. 25 at page 40, paragraph 3. They've absolutely said this, so they can't send you to jail. If they want to fine you, we're not going to get into the issue where if you're going to do that, judge, and fine me $1,000 for running the red light, could you please define dollars so I know what it is I have to pay? That's a biggie because they can't do it. The dollar is undefined. The Federal Reserve System admits that. The tax boys at the IRS admit it. So here we are with something called a dollar, and we don't know what it is. Well, the good news in California, you look up Section 6850 of the Government Code, and it tells you what it is. It says the dollar is defined as being a dollar, cent, and mill. Doesn't seem like a big deal, but this statute was adopted without change from Section 3230 of the Political Code of California in 1852. At the time, the definition of the dollar was found in the Coinage Act of 1792. That's one statute at large 50. You can look this one up on Google too. You're going to find out that it says 374 grains of 999 fine silver. That's the definition. But this stupid ass de facto national government isn't making any of those dollars, Judge. So where do I get them to pay you? I mean, damn. You just have to know. And but the documents you can get from me, check me out in my email and ask me. I'll send you what I got here. The list of what I got and what they mean. This is what you do to them. And this is all preliminary before you've even gotten to the arraignment, for crying out loud. And that's the next stop on our tour here. You get to the quote-unquote arraignment. And I say quote-unquote. You're going to see why. Because you go in there with about 100 other people on the same damn calendar in the space of about 90 minutes. And, the traffic commissar comes up to your case and says to you, well, how do you plead? Well, Judge, and by the way, I would call him by his given name. You may not have enough confidence to do that in court, but I would because it gets it on the record and it makes the bastards liable down the road if we want to sue them. I'm not prepared to plead, and if you have read the record, you will know why, because you're going to see that denial of counsel in there. You're going to see the bill of particulars to which the DA has not even acknowledged, let alone responded. So I don't know the nature and cause of the accusations. I also don't know the elements of the crime the government has to prove to get a conviction. Therefore, I am not prepared to enter a plea at all. And this last is a big deal, by the way, because elements of the crime, if you're in a traffic court, one of the elements is that you're a quote-unquote person required to have a quote-unquote license. seems simple enough, but when you know what the legal definitions of those words are, and that person, quote unquote, is for all intents and purposes defined as an artificial corporate entity, and you probably aren't one, and the definition of license, and straight from Black's Fourth Law Dictionary, you can look this one up, is permission granted by competent authority to do an act that without such permission would be a trespass or a tort, and thus be illegal. This is the definition of license. Wait a minute. I need a license of this type in order to travel in my conveyance, my property? I need the government's permission to get married? I need the government's permission to go into business? Think about this. But that's the legal definition, and that's what they have to prove, and they know damn well they can't do it. This is what gets your cases quietly dismissed with the hope that you won't be able to take it forward and get a judicial court to rule on it. They're going to say, well, it's moot because you didn't go to jail, you haven't been fined, we're not going to hear it. Well, I'm working on that end too, and we're eventually going to get the Supreme Court of the United States to take this case and decide one of them, and it ends all of them, because it's not moot. This is what the Supreme Court calls capable of repetition, yet evading review. And we are going to get them sooner or later, hopefully in my lifetime. We'll get to that part. So you can't enter a plea. What do? The traffic commissar enters a plea of not guilty for you. This is a supposedly neutral fact finder, right? That's what the Supreme Court says. The case is Toomey versus Ohio, T-U-M-E-I versus Ohio, 273 U.S. 510. And yet he's trying to act as your attorney with no known agency relationship with you. You might want to ask him in open court, what relationship is it you have with me that you can enter a plea on my behalf? If he's honest about it, he's going to say, well, you're a 14th War Amendment citizen, and therefore the relationship is guardian to ward. That's the relationship, but they can't sustain it. Now, they got a statute that says they can do this, Penal Code Section 1024. The statute's been around 150 years, and the same situation is true in Idaho as well. I've had occasion to sojourn up there for a while. I can't recall the statute right now, but it also goes back 150 years. There are no cases, no court decisions on this. How are they doing this? Well, the reason is that anybody that's asked that question probably has had their case quietly dismissed so that the Court of Appeals or the state Supreme Court won't have to rule on it. This is what happens, and a dismissal like this is just what you're looking for, because you walk out of there, you're not going to jail, not paying them a damn thing. So it isn't the big win we want on the record, but it will certainly do for a lot of purposes now, won't it? So we get there, now they set a trial date, quote unquote, and this is the first time you can now hit them with subpoenas, and we're going to do that like crazy. Those are other documents that are available. Check with me with my email. You'll see the documents I have in there. You get subpoena, what's called a subpoena ducis tecum, where you want the DA in particular to bring in all documents that were used to reach a determination, for example, that you're a quote-unquote person required to have a quote-unquote driver's license. They can't do it because they don't have it. A very amusing sample of this, or it would be a lot more amusing if it wasn't so damn serious. I had a friend of mine got a letter back from the IRS trying to answer his question, how did you determine that I was a quote-unquote taxpayer? Are you ready for this? This letter, I swear to God, says this. It says our decision that you're a taxpayer, quote-unquote, is not memorialized in documentary form. The bastards don't have one. So how in the world do they, A, know if you're a taxpayer, and B, how do you know if you're a taxpayer, how do you know how to refute the claim and put on a substantive and meaningful defense? It can't be done. This is the kind of argument that beats the hell out of the IRS, too, and they don't want to see this one coming. But I'm telling you, they have no way. They don't know. They simply don't know. So we get these subpoenas, and they're going to have to answer the subpoena now, because if they don't, they're running the risk here not only of contempt of court, which is comparatively minor, but all charges are going to be dismissed not only with prejudice, but you're then going to get on a special list there in the DA's office and the head judge down there. And next time they see a case like this come in there from a cop giving you a ticket, it won't even get processed. In fact, I've had this happen already in San Francisco. We could not get them to file charges when we made objections of this type. They refused to do it, and they're damn right not to do it. 3, it gets even worse, because if this court would be proceeding without jurisdiction, and they would if they don't provide this information, without jurisdiction, now the traffic commissar and the DA are going to be liable for these actions, and you can bring suit against them and collect damages. And I want to see some of that start to happen, because if we get 2 or 3 of those across the country, that's going to wake people up. Because without jurisdiction, they think they have all this judicial immunity, absolute immunity. They don't have it. They can't, because they're sitting there in a legislative tribunal, not a judicial court. And we're going to get them, and I'd love to get one case to the Supreme Court, because they're going to have to rule in my favor on every issue I'm saying here. And they are going to be liable. If they're acting within their jurisdiction, which they're not doing here, maybe they get away with it. But not the way I have set things up. So now we get these subpoenas, and I would also subpoena in a traffic case the cop who's going to be the only witness against you, and will almost certainly be testifying, at least in California, without even a DA being present, which raises a red flag right to start with. Because if you don't subpoena the cop as your witness, when you do get the right to confrontation and cross-examination, you will be limited to the questions that the traffic commissar asked him, and you won't be able to go beyond that. And then you take a timely objection, which you should do, and you go to the Court of Appeals, and they're going to say, guess what? Harmless error. Didn't matter, the conviction is upheld. In California, that's Article 6, Section 13 of the California Constitution, or at least the bastardized version currently in effect. It was nowhere in sight in the Constitution of 1849, and that's still in effect. That's the subject matter for another day, but I can prove it. And that's the one we want to use. So this is the sort of trouble they get into by doing this nonsense. So you get the cop in there now as your witness, and you can now sit there and ask him questions like, how much training have you had? Did they tell you what the definitions of, for example, the word person is, or license is, or vehicle is? I mean, do you know? And the obvious reply to this, if he says no, how in the world can you possibly go out there and lawfully write any tickets if you don't know the definitions of the words you're using? A jury's going to get that one loud and clear if it ever gets there. That's where I'm headed. And on direct examination, you can ask those questions. They will be relevant, and a denial of them will be reversible error. The other good news, even in traffic cases, I'm sitting here with at the present time, and a jury packet instructions of 584 of them. You wouldn't see 50 or 60 in a capital murder case. I've got almost 10 times that amount, and they're all relevant and they're all admissible. The denial of any one of which might well be reversible error and get your case sent back for a retrial, which is never going to happen. So that's another thing we have in the documentary packet here that they're not going to love to see. And in my local court here, they know this very well because they've got a digital copy I sent down there for safekeeping. And I said, if I get thrown in jail here, I can't bail out. So what I want you to do, the Superior Court Executive Officer, is get this over to the presiding judge in digital form so they can print out enough copies that we can then discuss the admission of these jury instructions. It's probably going to take them a week to do that with that many jury instructions, and it may be over 600 by that time. They're not going to do it. And what you do with the advertising we do and the documents we put in, they should be able to see a lot of this coming, if not all of it. And anybody that really puts up a fight is probably going to get their case dismissed, even if they're not right, because it's too much trouble for them to take nowadays, especially. And in traffic courts, even though the traffic court is their cash cow, they're going to get rid of the cases. They're too hard. They got all these other goons out there who are not going to know. They're going to get 500, 1,000 of them a day to plead guilty and pay the damn fine. I have no intention of doing that, and you shouldn't either. So this is, and I'll be the first to stipulate that some of my quote-unquote wins here, when you get dismissals, I would much rather have it on the record. But these work, and it's not just for this reason, because when I put these documents in, I personally challenge them to come after me. I give them RSVPs. If I'm practicing law without a license, come get me. If I'm an undocumented alien, come get me. Domestic terrorist, here I am. They're not coming, because they know they can't prove any of it. So that may take a bit of gumption here for you, and much more learning than you're going to have at first, but that's the idea. You stop these bastards in their tracks, and you do it a couple of 3 times, they're going to leave you alone. Even the tax boys are going to do that because they can't afford. See, that's the power we have. One person can do this. You get one case that gets to the Supreme Court, and they say, yeah, you're right. That's good across the country. That's the saving grace in the United States, which is true nowhere else that I'm aware of in the world, and nowhere else in time and history up until 1779, 89, when the Constitution went into effect. That's the power we have. That's what I'm going to continue to teach you how to use, and go in there and in court and give them hell, and you won't have to do it very often either. Thank you.